Fine, thank you. Masani najiona hapa.
We've actually si unavunja sheria.
Yes.
I was told it would
Actually, channel. Channel.
Yes, sama punya aja. Tahu ini mau dia. Oh, easy. Oh ya kita sama. Yes, yes. Yang bebas seperti kemarin. No, y cosa, yo lleva todo una cantidad. Kama ni fair ni yangu nikuwekea huko. Sio basi. Aichukue direct. Ala. Sema. Ningekuja hizo dada yako kidogo. Please, ningekuja itakuja mid center kidogo. Kukunja sasa. Kukunja na kukunja. Kukunja ndio kila kitu.
Victor Swanya Ogeto. Dave Wanjiru. Andrew Muge. George Wandati. Dr. Sakim Pat, and John.
Present, Lord.
My Lords, Your Ladyship, as I sit down, I seek clarity on whether it is only petition 565 of 2024 that this honorable court has before it today, or whether they are any other petition. I thank you.
We will take quorum on all the files that are before the court first.
Petition E015 of 2024 at Kerugoya. Petitioner David Muni Mazenge and two others who consider the National Assembly and 5 hours.
May it please your lordships and my lady judge, in E015 of 2024, the quorum for the respondents is the same, save for His Excellency the President, who has been sued in person and is being represented by Adrian Kamodo.
Yes, for the purposes of clarity, just I will report the quorum fully.
Dorcas will appear as the Attorney General. For the Attorney General is Professor Gidu Mwigai, Senior Counsel, Shadrach Mose, Solicitor General, Emmanuel Vita, Deputy Chief State Counsel, and Charles Mutinda, Deputy Chief State Counsel. For the National Assembly, Eric Gumbo, Paul Nyamodi, and Mugala George. For the Speaker of the National Assembly is Benson Milimo and Josephat Milioni. For the Senate, Professor Ojienda Tom, Senior Counsel, Moni Mukele Edwin, and Senator Hilary Sigei. For the Speaker of the Senate is Mercy Tanji and Peter Wanyama. For His Excellency the President, Adrian Kamodo. For Professor Kindiki, Mudomi Piankolu, Moses Kipkogei, and Ken Levy.
Your Lordships and Your Lordship,
My name is Kipe Mongai, appearing in this matter with the following. My Lord, in this matter, I appear with Senator Daniel Manzo.
Your name, please.
My name is Kipe Mungai. I thought I'd said it, my Lord. Kipe Mungai. Sorry. I appear in this matter, my Lord, with Senator Daniel Manzo.
Present, my lord.
Mr. Ndegwa
I'm present.
Honorable Jerry Maina,
Present, my lord.
Mr. George Sankimpa,
Present, my lord.
Mr. Andrew.
Mr. Kibe.
Yes, oh, sorry.
We are recording.
You are recording. Sorry.
Can you start from Dan Manzo?
Dan Manzo, Mr. Ndegwa
Present, my lord.
Senator Honorable Jerry Maina,
Present, my lord.
Mr. George Sankipa,
I'm present, my lord.
Mr. Andrew Muge, Mr. Kirabu Aduta,
Present, my lord.
and Mr. Kenneth Matiba, who is on the way, and Professor Ogada. Professor Ogada.
Present.
And Kenneth Matiba is on the way. My Lord, we appear in this matter that continues to be referred as Kerugoya, petition number A015 of 2024, that appears to have
Brought to your leadership this petition E015 2024, Kerugoya file. Again, we appear for the first interested party, that is the Deputy President of the Republic of Kenya, in this E015. My lords, again, let the record capture and show that council appearing for the first interested party appear under protest. Council are as follows: Paul Mwite, Tom Acharia, Elisha Ongoya, Faith Waigwa, Victor Soanya, George Wandati, and John.
Can we have that again?
Yes, I'm sorry. From what point, my lord?
From yourself.
Paul Mwite, Tom Macharia, Elisha Ongoya, Faith Waigwa, Victor Soanya Ogeto, George Wandati, and John. At the appropriate time, we will be going into the grounds and basis for appearing under protest.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given.
My Lord, before we start today, moves on that file, are there other files, especially file number petition E572, 2024, is it before the bench? Will take forums of the files which are before the court and that you can raise any issue?
My lords, may you kindly equally confirm whether E0, E509, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
Petition E13 of 2024, High Court of Kerugoya, Thomas Kimodo Maingi, petitioner versus Deputy President of Kenya, respondent, and the Honorable AG.
My Lord, that matter is not before the court.
Your Lordship is being called, it is the call that you know whether it is before the
We had a
We also want to know whether it is before this.
My Lord, and my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether you can also proceed with it.
When was it filed?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mamuye, who gave directions that it should come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
May it please the court. My name is Dr. Eboso. A petitioner in E541 of 2024. A petition that was filed on 8th of October. And a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. Raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Wambi, the second petitioner, and we were seeking clarifications with regard to directions on that file, because as we can see, the files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, your ladyship, we heard the court assistant call out petition E13 of 2024, and she mentioned the word Kerugoya. That is the file that was called. And in order for the record of this code to be systematically accurate and easy to follow, may I, with respect, ask that we get clarity on this file that was called out, E13/24 of Kerugoya, before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court. This
Senior Counsel Paul Mute, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard.
Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number E0113, which was consolidated in Kerugoya before it arrived here with E0114. 011414. Then we have application number E0115, also from Kerugoya. That is application before this court. And then we give direction on those applications. And then E565. Those are the three matters which are before this court and in which the Honorable the Chief Justice has constituted this bench for hearing and determination. If you there are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given direction pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them. Maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we well guided, and perhaps also state for record that we also appear in E015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Kerugoya is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Kerugoya, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we shall raise other issues? Just confirm on the question of the integration of that file in the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Kerugoya or in Nairobi?
Let me deal with that. Lord, for the purpose of E572 of 2024.
That file is not before us.
That's all I'm only saying. I have had the directions of the bench. The file is not before you. But I have instructions for the purpose of the one to take that petition was filed on 18th of October. The same day, the Kerugoya file were filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours are borders. The reason as to why Kerugoya files before the learned judges is purely because they have orders to stop the swearing in of the Deputy President-elect. The CJA could not have selectively decided to have only one file before you, my lord. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me loud and clear. Thank you.
Well, I had indicated
Now, I think we need to get something right. I want to clarify how these files are before this bench this morning. The three files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why we're here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My Lord,
just a minute, please.
Perhaps just to add that it's the numerous other petitions that are coming up.
Yes, my Lord, I believe now I can be able to make the clarification. We are starting with the immediate background that we need to make these clarifications, and we take into account.
Let us finish with quorum first. There's a quorum in E013, which was consolidated in Kerguelen with E014. Just take quorum on that file.
Your Lordship is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, if a team was not part of what was called, I've not heard it, perhaps it would be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated. Let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The direction from this court were very specific on 3 different files.
My lords, I'm well guided, but when Justice Mrima was giving the clarification, I never heard him clarify whether the Keroboya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Keroboya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
Let me answer you. You said that record speak for himself. And for record, matters which came from Keroboya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Keroboya was already consolidated. Those proceedings which took place in Keroboya consolidated these 2 files. So let that not be an issue here. On the directions issues on 11 by Judge Richard Mongo, these were the directions. The petitioner in E014 2024 to serve their amended petition on all parties. Similarly, the petitioner in E-013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the parties' response to the amended petition and petition E-013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E014, and petition number E013 are hereby consolidated. The parties who appeared before the Kerugoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we may now raise the issues that we want to raise, particularly arising from the issues in Kerugoya. And I
We will then proceed and take quorum on it. They were consolidated, so we will not take further quorum on this matter.
The Attorney General, I don't know, I have indicated to the court that I need to raise some clarification. You had read your subject. It doesn't override my right to represent my client. Can she then say her piece? I say mine.
Now, which matter are we now dealing with?
We have 0115. We have 0115.
My Lord, I wanted to say that
Yes.
the only matter they were filed before impeachment and they have been considered to be covered.
I think they do.
We have E15.
E15 has to.
Conservative, but E13 and E14, although from Kerugoya, they were filed before impeachment and they had no conservative member.
I hope I have then been heard without further appearances. My Lord, I'm leading the number of advocates in this matter from Kenyaga, E015.
Kerugoya 15.
Yes, Kerugoya 15.
Yes.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on the record. We did not trust that the Honorable Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordships, that you are convened by the Honorable Lady Justice Will, the Deputy Chief Justice. Lady, my lords, arising from that are one, a legal issue and a matter of Article 150. My lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My lord, may
I think I have a right to raise those issues.
Let's give Fellow Mugai time
Mugai.
I just wanted for good order. Okay, is that a clarification, Mungai?
My lord, I am Mungai. I believe he will speak in response as soon as I'm done. Let me finish.
My lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Mugai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my lord, the point that I wish to make is that I am acting for specific clients today, and that's the court. I should be having silence. He will respond. And I've indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. My lord, under the 2010 constitutions, the constitutions provide for the Bill of Rights. My lord, under the former constitution, my lord, under the former constitution, we used to have a practice in which we had unofficially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made last time. And my lord, we are also sitting here pursuant to an order made by the Honorable Chief Justice. My lord, for purposes of Article 165, I believe it's 4 of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my lords, arising from that.
Let us be discharge the directions of empanelment.
My lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. My lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My lord, I have a lot of respect for all of you that have appeared before previously. But my lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoys special privileges. Number 2, my lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my lord, and it is important that this issue is speak for the wananchi and with a clear conscience. 2 things. My lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my lord, is this, the issue of bias. And this is bias by the honorable,
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that again does not have to do with those prayers. The last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my lord, there are about 4 matters, one of them in which I appear, and this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see, why I say this is important is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application is clearly not permissible. So that, my Lord, I urge the court
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
That is not administrative.
If you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My lord, sir, just to add on what my learned friend has submitted on,
With the permission of the president, I wish to say I wish to make this clarification. The matters which are before us today, the three matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get appropriate, there should be no problem. We are all here to defend the Constitution of Kenya. So don't be worried. Don't be worried. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
Allow us to worry when we have grounds.
Senior Counsel Nute and Counsel Nebula, you know, when you argue like the way Mr. Mboy has argued, that court sat on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us at any time, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that court sat on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Murai, let it not be an exchange between the court and yourselves, because we are really very neutral party. Let us hear also from the other side.
We haven't really. E015 in the report. The deputy president is the second respondent, first respondent in fact. We haven't said our piece, and Elisha Ogoya will be making submission. But my lord, do give us, this is a very weighty matter. this E015 in Kirogo. The orders of your brother, Mr. Justice Munibo, were given at 4 p.m. Where did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night to try to give permit us to articulate these issues for the sake of the nation? We're not just dealing with the removal and the challenge to the removal of the deputy president. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Waiter. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go directly to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on Article 165, Clause 4. On the constitutionality of the constitution of this bench to hear these 3 specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is a Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number 2, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present Why did the Chief Justice execute her functions and her mandate under Article 165 plus 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the root of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That is why the Constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That 3 files have graciously generated expediency, and other files that were consolidated, that 6 files with the lead file 522, have no reasons why they should be before you. Noting that, Your Lordship, those matters were equally certified as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued on us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is impaneling, the Deputy Chief Justice is impaneling the bench. We are called, in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectfully.
My Lord, with your kind permission, for the record, Dr. Kamoto for the 5th respondent in E015. I believe the reason we are here and the reason why we took forum is because we recognize that there are different parties in these proceedings. So it will be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the audience of the court. So in this regard, my proposal is as follows, that each of the party whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we're able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and to mourn. So we respectfully urge that we get an opportunity for each of the parties to ventilate the issues, because the 5th respondent has a pending application which is duly filed, a preliminary objection which even contests the jurisdiction of the High Court to hear the matters, because it is a matter relating to the nomination of a presidential of a deputy president, which in our view lies squarely within the domain of the Supreme Court. So we once accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
For the first interested party.
Mr. Lord, just a minute. I was about to interject when when counsel, Mr. not by the other one.
Jagwaji?
Yes, Mr. Jagwa was addressing, and that is exactly why I wanted to. I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which
the application can only come after I have spoken.
We are now making an application, you respond.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4 to empanel this bench. Your Lordship, this is the background of my application, that on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject, to seek your guidance. My name is Muzomi, appearing for Professor Kindiki. Listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge,
the business of the day. There were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We've not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes. Yes.
But my lord, you are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you are being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, Ndegwa and my friend Kibe, is that you are taking the court for a long ride and we're ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you would say?
My lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your lordship's stand. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My lords, if it pleases the court, my name is Andre Mohi. I am acting in person. We filed an application for a certificate of urgency on the 8th of October, 2024. Before this bench was in panels on the 14th of October, 2024. Unfortunately, some of the credit we were seeking have been overtaken by events. My lord, and today, as the part of our application has not been placed before you, and we are just concerned that our application will once again, events will once again overtake our application. My lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Lady, for the 5th interested party in 15, can I just be heard for 1 minute only? My Lord Judge asked an important question. How do we move forward? Now the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Mrema about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We add that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guide and Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is that Mr. Boy applying for an adjournment? Because he's saying, and perhaps it's wrong, that even the recusal application comes after the termination of the question when paneled. If that be so, and they may leave, they normally leave court, they left Senate, may leave court, let them say whether they are applying for adjournment.
Is that remark they normally leave court where the left Senate might palatable in this court, my lord? I need that.
No, because it's an adjournment.
No, is that remark palatable for my lord and my lady? My lady, because you know we have decorum at the bar. If you have a professor of law misbehaving at the bar, then I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem with withdrawing the remark, but the point is, it is a vain application for adjournment. Because Mr. Ware is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
I answered the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I did withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem with withdrawing. You're my friend. No, I have no problem, my lord. I withdraw the remark, but there is practice.
Thank you. Let me now address the question as addressed. My lord, Professor Jenda was my teacher and my mentor for many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through Lanet's colleagues, Kibe Mungai, and Lanet colleague, Mr. Njegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that regard that my Lord Judge Grima asked, how do we move forward? I also had my learned mentor, Professor Kidu Muigai, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Leadership again on how to move forward.
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light. It is now. They actually knew of it, and this, or should have, they would have found out. The letter which was written this morning, which we have, it was received on that, it was written on the 20th of October, has actually one pertinent question disposed whether the file was actually taken to the Chief Justice and at what time. So, they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to ECJ, possibly because of the absence of the Chief Justice. They will have to tell themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what you are told. That, as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fraction of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue when the Chief Justice, Deputy Chief Justice sat, does not arise. As to what happened on Saturday, again, this is purely administrative.
My Lord, for the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And My Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners, is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add, this court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.
For the next 1 hour, we look at what's happening in the country. So, politics versus the law. There's an unprecedented battle that's going to be taking place in the courts today. We saw it's a culmination of a political contest that was there in Parliament, in the National Assembly, in the Senate. It's still going on. The National Assembly has already approved President Ruto's nominee for next Deputy President, in record time. Honorable members, I was given, it's okay, yes. Let me read the name. No, it's fine. Yes. Honorable members, okay. The ayes have it. And that was it. That time, Gachagua is with Dr. Dan Gekonyo. Then Gachagua comes out on Sunday and says, I cannot believe that this could happen. I cannot believe. So the question we are asking today, okay, should Gachagua just look back and see, like he said, the relationship between him and his boss is irretrievably broken, right? This one is gone, right? Should he just say, okay, he meander?
Eric, we've seen ugly divorces in politics. Anyone who thinks that there's an element of permanence in these things has not even begun to understand our politics. No. Just like me, I have no clue what is actually going on.
Yeah, you don't know.
No, I don't. I am seeing court cases. I am seeing people going to I am seeing all these things. But I honestly don't know what is going on.
You don't get it.
No, what's in the public domain is a symptom, a sign of what's going on. But what's actually going on, I cannot claim to actually know.
We've invited Herman Manyora to come so we can also hear his thoughts on this. Herman, good morning.
Morning to you.
How you doing?
Wow, wonderful. Glad to be here.
Glad to be here.
But I'm not happy that the lady's not here. Last time I was here, she wasn't.
She's listening and she knows and she hears.
She's enjoying. Let the lady relax. Let her recharge her
Ogaland
batteries.
or
wherever she's been everywhere. She went to Ogaland to witness the coronation of her uncle as a king.
Oh, wonderful.
Yes.
Congratulations.
She's royalty, Bana.
Wonderful.
Yeah, so next time you see her here,
okay,
treat her as the royalty that she is.
Wonderful.
Yeah.
Wonderful.
So karibu sana.
Asante.
City will give you the day's proverb. So give Manyora the day's proverb. This week we have been looking at proverbs from the Maghreb.
Yes.
Last week we were in the People's Democratic Republic of
Algeria. Yes.
And today, this week we
are in the Republic of Tunisia.
Yeah, in the People's Democratic Republic.
Well, there are people there, but they don't want to emphasize the people. And they are a democracy, but they also don't want to emphasize the democracy. So they're just the Republic of Tunisia.
Okay.
It is Africa's most northernest. That is my country. You don't get more north than Tunisia. All right, an interesting country, this one. You know, these Maghreb countries are very interesting. The natives of Tunisia are actually Berbers. And you find them right across the Maghreb. But they're not the most popular.
As in Waoni Kinyozi?
BER.
Oh.
Okay. So wale ambao wanakunyoa nywele.
Okay.
Yes, they're the natives.
Okay.
But the Phoenicians, people who decided to move there over the years, ended up there, and they are by far, no, they're not the majority. Right now, the majority are actually Arabs. Okay? All right. I'll go into the details later. Even if he wears a valuable harness, the donkey does not turn into a racehorse.
Even if he wears a valuable harness, the donkey does not turn into a racehorse. Herman, what's your interpretation of this proverb?
I think basically it's about outward appearances. It's about what Jesus said, washing the outside of a cup and leaving the inside. And you basically don't change who you are through ornaments and things of that nature. Yes.
You are still who you are.
Yeah, you're still who you
are. Hata ujipambe vipi.
So it's better to concentrate with the inside. Yes.
Very nice. That's a good one. City says he doesn't understand what's going on.
He doesn't
when
understand.
he look at politics.
And I don't blame him.
Do you get what's going on?
I do have an idea.
What's going on?
A rough idea, not quite a clear idea. I know there is politics. The politics to remove Rigathi Gachagua from office. And an attempt to do it through the provided avenue, but making a big mess of it. And as a result, giving Rigathi Gachagua an opening to challenge the impeachment in our courts, and thereby raising a lot of problems for everybody. Because impeachment is a political process. Ideally, at the end of it all, one Senate finds the governor unfit to hold office. That should be it. The president, that should be it. Deputy, that should be it. But because the people impeaching Gachagua are in a hurry to do so, they have made a lot of mistakes along the way. There are so many flaws along the way. Not even to mention the flimsy grounds upon which he is being impeached. Because that's not an issue. This is a political, even if they don't like your face, you can be impeached. But they are compelled by the people of this country through the constitution they gave themselves to do so in a manner provided for by the law. But what is even more serious for the impeachment cartel is that, you see, the people are not convinced. One, they are not convinced about the urgency of this. They
Which
don't
people?
see it as important.
Citizens?
The people of this country. They don't think this is urgent. And they think there are much more important things. And secondly, the reasons for impeaching Gachagua, much as they are not important because this is an impeachment, the people are not convinced those reasons, those grounds make sense. So here are people forcing an impeachment on the people of Kenya, and the people are saying we are not happy with this. Even those who don't like Gachagua. People don't have to like Gachagua. They just don't like what's going on. And I think that's the situation we find ourselves in.
You're
in
saying
summary.
that those...
And I hope CT has now understood.
You're saying that those who are pushing for the removal of the deputy president have made a mess of it.
Yes.
How so?
I've told you first to begin with the grounds themselves and how they are prosecuted. Even if everybody knows about what has gone on in the process of prosecuting this case, both in the National Assembly and in Senate. But much more critical in terms of the speed with which the whole thing is happening. Gazette notices at night and think that they're in a hurry. So you find there are a lot of flaws in that manner. Look, one glaring one, a man falls sick. Whether you think he's feigning sickness or not is not within our province to say. And you say this process must go on. And among the people saying this process must go on, even if the main person who should be testifying is in hospital. What baffles people, this is coming from people like Orengo. It is so what is the hurry? If a man is admitted in hospital, like we all could be admitted in hospital, what is the hurry for? There are no timelines. So for people who are respected, like senior lawyers, to come and tell the country that there are timelines, this thing is time-bound, when it's not true. Even if it were time-bound, they were still up to Saturday, going by their 10 days, which is even wrong. But even if it is also 10 days, you could even open it up and say Saturday is a holiday, Sunday is a holiday, Monday is a holiday. So there is no escape route. There was nothing like 10 days.
There was no reason to
time-bound.
finish it on Thursday.
So whichever way you look at. So these are the things that are irritating the citizens of this country. Not because they love Gachagua. Many of them don't, frankly speaking.
But City, do you now understand then what's going on? Because the bottom line of this is, why remove the deputy president? What really is the reason? Like
Politics.
you said,
that's politics.
Like you said, the charges that were brought, one looks at them and you're like...
There isn't one that anybody sensible can come and sit with us here and tell us, Manyora, this one is a ground for impeachment. Much as, like I must say this repeatedly, impeachment is a political process. You could impeach CT because you don't like his face.
But that's not provided for in law.
You can find a way of calling it. You can find a way.
Gross
because the way he
violation.
smiled and the way he frowned when he met the president, that is enough to impeach. It shows his intent. Yeah. So you can say anything about impeachment everywhere in the world. The grounds are really not important. But in this particular context, because of the charged politics in this country, because of the ethnic configuration of this country, it is always important. And I'm addressing myself to the future of this, in the matters of this impeachment. In the future, before you impeach a president or a deputy president, please just understand what country we are. There are so many flashpoints in this country. So what you do, look for really reasons, even if it's one, and then impeach somebody. Don't go fishing for things, because then you are going to, nobody will believe you. But again, like I've said, those processes the way they are hurried, denying Gachagua the chance to come and tell his story to Senate, and so on and so forth. Yeah, and look at public participation. They themselves invited public participation. Nobody. It's not written anywhere that during impeachment you must have public. It's not written anywhere. They invited them. They know that in the recent past, legislation has been overturned by the courts on the basis of there having been no public. So they want to forestall that by going for public participation. Then they make a mess of that public participation. So, I mean, they have a problem. Look at the appointment of Kindiki itself, nomination of Kindiki. They know there's no IBC. Nobody asked them to go to IBC, but they went there. So they have been inviting problems for themselves. Finally, so that CT may be a good student and get an A, what you are saying, the cumulative effect of all this is that we enter into a minefield called litigation. So people are going to go to court now. So that now City Muga knows really what is happening. You are putting the judiciary in a very difficult place. Because ideally, judiciary should not interfere with the politics. Because politicians have bad manners. If you follow them, you'll also get dirty. But now the judiciary is finding itself in a very difficult situation because they must enter a field where they shouldn't enter. Because there's no way they will come here unscathed. They will actually be affected. They'll be muddied.
However way
whichever way they rule or they determine these issues.
You know, the thing I find confusing, and I found confusing for a while, every time we talk of our politics and then academicians weigh in and we start talking about the structure of our politics, whether it is centric, whether it is democratically centric, whether it has a social leaning. And then I look at our lived reality and I realize that's not quite. You see, the reality of our politics is that each and every political party is a business enterprise.
Correct.
And everything that is done and even the problems that arise and that we refer to as political problems, they're not political problems in my opinion. They are business problems. Because everything that you hear being leveled against the deputy president, if we balance it against what it is that the protests were for, the Sufria on the head protests, the Gen Z protests, what were those? Those were economic issues that we were complaining about, but then they were politicized because the moment you demonstrate, the economic issue has gone to the streets and you're demonstrating. It's an issue that we know it's a genuine issue, it's a tangible issue. Then these matters go to court. Now, in what form do they go to court? Our constitution allows our courts to have a say in some of these things, like we are told the processes. Now, if everything in our economy, anything that is termed as being political, has a very strong economic basis, then why are we focusing on talking about the politics of it when the reality is not the politics? And why do I say this? We've had heated discussions and disagreements of this nature before. We've even had situations where people have been killed in large numbers because it is said it was political or politically instigated. But if you look at the root of it, the economics of it, some claiming this land is theirs and other people have occupied it. That's not political. You're talking economics. And then we look at the balkanization, or we look at the associations that people have and what we call political formations. Again, at the center of it, what is it? Is it politics? It's certainly not politics. Now, the deputy president made the mistake of telling the whole country in the world this particular reality. When talked about shareholding, that is what he did. And he was not wrong. There are certain cardinal sins that one must not commit because there are rules that govern the economic and the business principles that we have in this country that are best manifested in what we call our politics. The things you don't say. The things you don't make public.
But he's a truthful man of God.
So let me ask you, City. Okay, so all that, yeah, it's economy coming into politics, it's truthful, and it's, so what is the reason for this breakup of relations between, because this is it, it is William Ruto and Rigathi Gachagua. What is the issue?
If you ask me,
or do you think the issue it's not even them?
The issue is money. I don't know how it is that it has come in. When I don't understand, I'm trying to figure out what exactly have they quarreled over. Because, Eric, I don't understand. I honestly don't understand how it is a sitting president will allow a process which will shine this spotlight on him as much as it's on his deputy, and a parliament that starts a process that will shine this spotlight again on them, and in the most adverse way possible. You see my confusion. Why are you allowing us to see you in a light you'd prefer us not to see you in?
That's the question.
Because that's what they've done.
That's the question. Even in a simple thing, I was saying, you send Gachagua staff on compulsory leave.
Yeah. Surely.
Constructive dismissal. But that's not even what we are getting, apart from the unfairness of it all. Bordering stupidity, actually. People get to ask, you mean there were this number of people in Gachagua's office? Busybodies? People who inherited a government, they told you the government was broke, and they were able to pump so many people in an office.
And we were paying
busybodies, holding titles which professionals in this country can only dream of. They are people well trained, well educated, with experience, dreaming to get to job group SOT, and they are not, and they are retiring down there. And here are busybodies being just pumped there and given. So people are asking, what is all this? So you are right, Muga. You make people see things and say, what's wrong with these fellows?
You're airing your dirty linen.
Yeah.
Yes,
in public.
When Gachagua speaks outside Karen Hospital, certain things come out. And like you say, spotlight on the president. People say, can a human being do this to another human being? What Gachagua did is not important at that time. The public seeing that lady with her tears are not bothered about the other things behind. No. Because pirates occasionally throw each other in the sea. There's no honor among thieves, you know that, eh? But that is not what people are looking at. What the human eye is now picking, and it bites the heart. What comes out is what they are now seeing, that image. And they conclude that Ruto is not a good man. They are not interested, and they don't even bother about what could have led Ruto into doing that, because then he has not told people why. And even if you said, some people say like there can be no reason big enough for you to treat another human being in that manner. You know, you see, like even from a very professional way, you cannot withdraw somebody's security, because security is not a privilege. I think that any of us can apply for security, and our risk will be assessed, and we shall be given or not given on the basis of that assessment. And how many of the guards we get will depend on that assessment. You may not qualify. I may qualify. You may qualify. I get 2, you get 5.
Yeah.
You remember the saga between Ruto and Matiang'i?
Yeah.
So how do you expose a deputy president? Sure, if it is true, he doesn't have, and the family is driving him, optics in a small car. These are, and they will do that. They will use those optics. So it's also true that, like you, Muga, a lot of things don't make sense.
There's a lot going on. There are those who have said that maybe this is just smoke and mirrors. Divert attention of the public towards something.
All along I thought so.
Diffuse something else.
Until I've seen, if they are still acting, they must be, what award is this? It's Oscar award. They must get something. if it is true they are acting. Remember the Uhuru, Raila, Ruto circus game. Up to now, nobody can tell me they know what happened. Was Uhuru actually genuine? Did he actually support Raila? Or was it a game involving Ruto and Uhuru? Or was it in fact a game involving the three? You can't tell. This is politics. And it won't be the first time. I'm a student of history, and I know things like those have happened elsewhere. So even now, it is quite possible, like you say, these guys are acting.
You know, that's what they call the long game.
But when I look at how far it has gone,
it's
I
not
begin to
stretching.
doubt that they could be
It's
acting. They
stretching
can't be
beyond-
this smart.
Yeah.
I'm not saying they are not smart.
So, Herman,
Yes.
should Rigathi Gachagua read the room and just see? Like he said when he spoke outside Karen Hospital, he said clearly this one is coming from the president himself. This is all sanctioned by the president himself.
I think politics is a war. Politicians are perpetually at war against each other and so on and so forth, which is normal, really. So to ask Gachagua to leave home, to leave the arena and walk home, is to ask him not to be a politician. So long as he's a politician, he will stay in the ring and fight until he's knocked down. They count 1 to 10. Politicians don't just take a walk; they fight. So we expect him to continue fighting. If there was a time he would have left, it was a time before the process got into a point where somebody could call a point of no return. Meaning, like people have always argued that if you are impeached, you can't run for office, at least not in the near future.
Yeah.
That is the time he would have resigned. But now, what is there to gain by resigning? But basically, being a politician, he will fight to the bitter end.
To what end?
To the bitter end.
What does he gain?
There are many things to be gained. Top on the list is that there is always a chance he can succeed and remain the deputy president. That's worth fighting for. Okay? You can also fight to prove a point. You can also fight so that you don't give your opponent the pleasure of walking off laughing and enjoying that he has crushed you. But there are big ideals for which he can fight. He can fight for the Constitution. Because there are many people, I included, I'm sure you are included. We want to stretch our Constitution and see the limit. Let's see how it can go. We want to look at our laws. We are looking at our lawyers. Is it just the English and the good suits, or there's something about them? We want to see something among our lawyers. They say jurisprudence. We want to see it grow. We want the law to grow. We want to see
our judges.
Can our judges stand for this country? Can they stand for the Constitution? Can they work without fear or favor? I understand the Chief Justice today is meeting the President on the matters of intimidation of the judges over this. We want to see how far can the judges withstand the heat from State House. This is what is seeing. There can be no better time to be alive in Kenya than now.
That's all good
so
for us
that,
as spectators.
We want to cheer on Gachagua.
It's all good for us as spectators.
Cheer him on. Let him go on. Let him help us see whether our Constitution can be lived.
At what personal costs?
To who?
To Gachagua himself.
The moment you
look at what Dr. Gikonyo said. He said, among the things that you must consider is that even cardiologists now accept that there's something, a condition called broken heart.
Yes.
That you go through such pressure and such disappointment that it actually causes you bodily harm.
But even love causes you such...
Exactly.
So
it's extreme emotions.
Exactly.
Yeah, those are things that happen to us, but the scale varies.
That extreme emotion, we have seen the scale. It has taken Gachagua to hospital.
Yes.
He has been admitted to hospital.
Yes. Who tells you the other opponents are also having it easy?
Well, that's what I'm saying. For him, Gachagua has already seen where this could take him in terms of personal costs.
I want to tell you
So
this.
should he really continue to push against that?
He should continue, and I'm sure he will continue. You've seen a politician in parliament coming to take oath of his office with oxygen. Yes, God rest his soul, he later passed on. You see, the moment you enter politics, there are certain risks you must be prepared for, including your own health. Let me tell you this. Many of the politicians we have in this world, let's talk about this country, have diseases which you don't need Gekonyo to tell you, which you can directly attribute to the engagement. These are the hazards in politics. Yeah. Including your lifestyle, including developing diabetes because you don't have time to eat. There are many stretches you go through without eating. Then you trigger things in the body and you get diabetes, which you may not have even gotten, like Manyora